Good morning, everyone, and welcome to THLA's webinar with the Texas Workforce Commission today on Monday morning. Welcome to all of you. We have a lot of interest in this session. I believe we've received over 340 registered participants to join our expert panel this morning, who's here to provide a lot of answers and value to you all who I know have many questions top of mind regarding the Texas Workforce Commission, their efforts during this crisis, and unemployment benefits. As you'll see on your screen, there's sort of a note of who's on our panel this morning. There at the top, the Texas Workforce Commissioner for Employers, Mr. Aaron Demerson, along with several attorneys from the Texas Workforce Commission. We also have a couple of officials from the Governor's Office, Economic Development and Tourism Office. And so what we'd like to do from the THLA perspective is kind of allow the commissioner and someone from the governor's office to make some introductory remarks, and then we'll sort of go through some questions that we believe are very important to be addressed on this specific call. You all have also sent us some questions since we sent out the link for registration, so we have incorporated those questions into the list for the Workforce Commission. But before we dive right in, let me just remind you that THLA continues to update our website every day, sometimes multiple times a day, with the latest information for hoteliers and for our members on handling this crisis right now. So if you go to texaslodging.com and you see there on our home screen our COVID-19 portal, you click on that and that will get you to the resources that we have, again, updated daily, if not hourly sometimes. So my name is Brian Sullivan. I am one of our in-house attorneys at the Texas Hotel and Lodging Association. And on behalf of our CEO, Scott Joslove, our General Counsel, Justin Bragel, our other attorney, Neil Patel, I'd like to go ahead and introduce Commissioner Demerson and kick off the call. So I know we have a lot of material to cover and a little bit of time to do it over the 60 minutes we're together. Okay, so Commissioner Demerson was appointed by the governor in August of last year to be the Commissioner for Employers at Texas Workforce Commission. He has a lot of experience in executive level roles in state government, and even a background in economic development and tourism at the governor's office. So he is very well versed in even our industry and hospitality and how important it is to the vitality of the Texas economy. Commissioner Demerson, thank you again for being here this morning. I'd like to go ahead and turn it over to you to provide whatever introductory remarks you'd like.
All right, thank you, Brian, so much for the introduction, and to you, Scott, and Justin, thank you guys for holding this call and for the invitation for us to participate, and just for your continued dedication, leadership, and your commitment with the Texas Hotel and Lodging Association. I've been in the trenches with you guys, as has been mentioned, in the governor's office, serving as executive director over the economic development and tourism team, and just fond relationships with the industry over the years. And so on behalf of Governor Abbott and myself, let me thank all the folks that are on this phone, on the call today. We appreciate the leadership and the investment that you guys have been making in our state, which is very important. We thank you for what you're doing today as well, but not only for what you're doing today, but what you've done always, and that's basically just taking care of business, and we don't take that for granted at all. As been mentioned, Governor appointed me to this position in 2019, and I have the privilege of serving as the Commissioner representing employers, and we want to make sure that we're doing what we can to make sure that you guys are taken care of, especially in this critical time period that we have here. It's been mentioned, I have 4 dynamic attorneys on our staff that are waiting to answer questions. Tommy Simmons, Elsa Ramos, Melissa Chapa, and then Mario Hernandez, who's answering the phone calls at our hotline right now. Dynamic attorneys that have been answering calls for the past 3 or 4 weeks now, related to questions that you, our Texas employers, have. And we were fortunate to talk with Justin and Scott last week, and this kind of prompted this call as well, based on some of the information that Tommy and Scott and Justin were talking about. So we're delighted to be on this call today. These attorneys have been fielding calls over the past 4 weeks, as I mentioned, and we're looking forward to answering these questions. What I want you guys to know, statewide, we have local workforce solutions offices, and I want you to touch base with those offices, because those are the boots on the ground for anything that you need in your respective area. These guys have been there in the trenches, and they're very important for everything that you guys are doing. I want to briefly highlight some of the things that that have been addressed thus far with COVID-19. The governor took action right away and waived the waiting period. There's no longer a 1 week waiting period. In addition, we waived the search requirement that was that's mandated for individuals looking for employment. And a number of different actions. The governor asked for designation from the SBA, and that was received as well. And so there are a number of loan programs that are out there that are available to employers in our state. And the governor's small business team and the SBA are working hand in hand to make sure that those are made available to our Texas employers. As we move forward, there have been a number of initiatives here at TWC that we've taken, a number of phone calls that have come in, unprecedented numbers that we've received, and an unprecedented number of claims that have been filed as well. But we want you to know that every call will be answered, every question will be answered, and we're going to do what we can to make sure that you're taken care of. And so we've increased our hours 7 to 7. I think we're probably operating 7 days a week. You can't go 24 hours, 24/7, because you have to allow the computer to regroup, in other words. And so, but we're there extending hours. We've increased the staff that's available as well. And so we're doing everything we can to address those questions that are out there from our employers, but our employees as well. And so we're looking forward to the call. I know I have the governor's office on the line as well, and I want to allow Adriana Cruz, and if Adriana is not there, Kelly Spillane to have a few remarks before we proceed ahead. So Kelly or Adriana, I'd like you to add any opening comments that you might want to.
Well, thank you, Commissioner Demison. I would just like to say that the Office of the Governor is honoured to be partnering with you on this call. I'm delighted to be here to represent the Office of the Governor. I'm the small business advocate for the state of Texas, and so my particular contribution to this call will be answering questions that anybody might have about the resources available statewide or federally for small businesses at the moment, and any of the new coronavirus resources that have been recently instituted. So delighted to be here and honoured. Thank you.
All right, Kelly, thank you for joining us. And so, Brian, we are ready to rock and roll and looking forward to answering the questions that have been submitted and those that will be submitted as well. And so we'll turn it back over to you, Brian.
Perfect. Thank you both so very much. And before I dive into our first question, let me remind our audience that this entire webinar is being recorded. And also, for any questions that you would like to see answered, please submit them through the question and answer feature on your Zoom screen, and we will get to as many of those as we possibly can. Okay, so let's go ahead and jump in. Just a first threshold question, Commissioner, whoever you'd like to answer this one. First of all, who is eligible for benefits right now?
Okay, and I'm going to let Elsa to answer that question. And I'm going to ask you this question. Can you see Tommy on the screen right now? Tommy Simmons?
Oh, a little more.
Right.
Okay.
All right, Tommy, that's Tommy Simmons who's joining us as well. And I have Elsa Ramos on the line and Valissa Chapa as well. And so Elsa, you go ahead and take away that first question.
Yes, sir. So who is eligible for benefits at this time because of the pandemic unemployment assistance that is now being implemented since the CARES Act? Anybody who was working and is no longer working can file for benefits and may be eligible. So before the PUA, Pandemic Unemployment Assistance, came into effect, only those employees who had regular employment with an employer could file for benefits, which left out independent contractors, sole proprietors, etc. Now, pretty much it's open to everyone who was, or anyone who was working and is no longer working. So if you're a sole proprietor, independent contractor who had been denied before, there are benefits available for you now. So make sure everybody applies if you think that you could be, because that's the only way to tell really, is to apply and find out if you're eligible.
Thank you, Elsa.
Thank you, Elsa. And speaking of the application process, are there any insights you could provide in terms of when employees go to apply for unemployment benefits? Are there any tips or ways they can be most efficient in marshaling their application forward?
Yes.
So you're asking me?
Yes. I'll go ahead. I'll address that. I know there are opportunities. We've extended our timeline, and on our website, the TWC website, we're looking at different hours that one may call in or are going by your area code. We've kind of instituted some of those type of processes. So if you have a 972 area code, then maybe you're calling in at a certain time frame or so. And so those are designated on our website. And we're doing that to try to reduce the number of calls that are just coming in all at one time. Those are some of the things that we're doing from that standpoint. There will be resource email addresses that the team will give out. Let me tell you, we represent the employer side of things, and we have a Commissioner, Julian Alvarez, that represents the labor side. And so there will be resources that we'll give for their hotline or their email address that might be of benefit to those trying to apply in that regard. But we're working hard to make sure that folks are getting in, and let me say that folks will get in, and we'll make sure that every question is answered, and we're going to make sure that we're getting that information and resources to them in a timely manner as best we can.
And if I may add, Commissioner, I think one of the frustrations and that leads to the desperation of claim seekers out there is that they think that they're going to be denied benefits because they're going to be getting benefits from the date they file. But we've been assured that claimants will be getting benefits from the date that they were laid off or were no longer able to work. So even if it takes a little bit longer than they want to file a claim, they're going to start getting benefits from the time that they stopped working and not from the time that they filed a claim. So it's important for everybody to hear that.
Thank you, Elsa.
Thank you. It appears already we're getting a lot of questions, so I'd like to kind of go ahead and hit this next topic because we have several people asking about it right now through the Q&A box. But could one of you please provide an overview of the shared work program through TWC and kind of an overview and how that works?
Sure, I can go ahead and answer that. So the shared work program is a voluntary program that...
We lost you, Melissa.
Elsa, go ahead and pop in.
Yeah, the shared work program is a voluntary program for employers that don't have enough work to keep everybody basically at their full-time hours, but they don't want to implement layoffs of part of the staff. So if employers have enough hours such that if they reduce hours across the board from 10 to 40%, keeping everybody working, but a reduction from 10 to 40% in the work hours, they can then participate in the shared work program where their employees work, the number of hours that are available, and then a part of the weekly benefit amount that these employees would get from being completely unemployed gets added on top to their wages to help supplement the hours that they've lost. So in order to do that, you would want to either go to our webpage to participate in the shared work program. If you go to the Texas Workforce Commission webpage, across the top of every single page, you're going to see a red banner with 3 links on it. One of them is going to be employers, job seekers, and childcare. Employers, click on the employers. You'll be taken to a page where resources are compiled there for you, and you can find information about shared work.
Thank you very much. Oh, go ahead. Yes.
Hi, just to add a little bit of information to that, a lot of employers have asked if their unemployment tax rates are going to take a hit if they engage in the shared work program. The answer is no. And so that might be a good piece of information for employers to know as well. Your tax rate will not be charged if you qualify and voluntarily engage in the shared work program.
Thank you very much, Melissa. That has been a concern and an ongoing question that we've been receiving at the association. We appreciate that clarification. Let me kind of transition a little bit and ask whoever would like to take this question regarding workers who are part-time and their eligibility for unemployment benefits. First of all, how many hours constitutes being part-time as an employee? And what are the eligibility requirements for those folks when it comes to filing a claim?
Do you want to take that, Tommy?
Yes, I'm Tommy Simmons, and there's no official definition of part-time. Usually that's defined by employers in their policies for purposes of who qualifies for what kind of benefits or something like that. As far as the TWC is concerned, a part-time unemployment claim is officially known as partial unemployment claim, and there's a specific threshold for that. Usually that involves somebody having a reduction in hours that is not their fault, and the reduction in hours causes a reduction in earnings below a certain threshold amount, and that threshold amount is 125% of the weekly benefit amount they would get if they were totally unemployed. And there's a little bit of math involved, but because unemployment benefits are about half of what the normal weekly earnings are, that means that 125% of that would represent about a 3/8 reduction in hours at least. If somebody has at least a 3/8 reduction in hours, then that works out mathematically to about 35%, then they'll probably qualify for partial unemployment benefits. And that's a very innovative method of allowing for unemployment benefits that encourages people to work as many hours as they can, because if they do, they will end up with 25% more money each week than somebody who is simply unemployed and getting their unemployment benefit amount. So that's a good thing to do. Part-time workers definitely can qualify, but if they're working their customary hours in their part-time job and they haven't had a reduction in hours, then they probably won't qualify for unemployment benefits. It all depends upon what their prior earnings were and the relation of their current earnings to their previous earnings.
Thank you very much, Mr. Simmons. And actually kind of a follow-up to that, and something we've been getting some more questions on in the last 30 seconds, quite frankly. Are salaried employees who had their pay reduced or had their pay cut, are they eligible for benefits?
Maybe not. If they remain with the company despite the pay cut, then they won't qualify for partial unemployment benefits because they are not partially unemployed. If they're working their customary hours, despite the pay cut, that's not enough to be unemployed to where you can file an unemployment claim. But we also have something known as the 20% rule. That's a general principle, general rule of thumb, under which somebody who has a 20% or more cut in pay might have good cause connected with the work to quit and file an unemployment claim. That's a separate type of claim altogether. That way, if they quit, they're on total unemployment. But usually that's not really all that good a trade-off. If it's just a 20 or 30% cut in pay, then because unemployment benefits are about half of what the normal weekly earnings are, that person would be trading a 20% or 30% cut in pay for an unemployment claim that's worth at most 50% of what they were earning. So that's not really all that good a benefit. Although I will say that if they have good cause to quit and they do quit and they collect unemployment benefits because of that, they would still be eligible for the $600 per week additional payment called Federal Pandemic Unemployment Compensation, FPUC. That's the $600 extra that everybody's been hearing about. They would qualify for that. And since that's available through July 31st, that would be a little bit of additional income.
And that $600 you're referring to, that was part of the CARES Act that was passed by Congress, correct?
Yes, sir, that is.
Thank you, thank you. Okay, let me ask whoever would like to take this one on the panel in terms of the base period and how that works for determining eligibility for the amount of employment or the amount of unemployment benefits available. Can someone please explain for our audience how you determine the base period when it comes to computing the benefits?
Sure, and I can take that. So employers file quarterly reports, and all of your employers should know that. Most of them will know that they file reports to TWC on a quarterly basis. So January, February, March, first quarter, April, May, June, second quarter, just simple calendar quarters. And because of that, we get the information in quarters. TWC figures out the base period in quarters. And it pretty much works like this. The quarter when someone files the claim, not when the job separation happens, but when someone files the claim, that quarter, we don't count that. And the quarter before that, we don't count that either. We go to the 4 quarters before that. And that's known as the base period of the claim. And that period is very important because that determines what employers could be charged back for a claim if they reported wages during those 4 quarters. But for claimants, that's the period of time that we look at to see if they have sufficient wages to sustain a valid claim. So if someone does not have sufficient wages in that base period, and for that they need to have wages in at least 2 of those quarters, and they need to reach a certain threshold. It's not sufficient to say, well, I got $30 reported in one quarter and $30 in another. It has to be a certain threshold based on a weekly benefit amount. So if a claimant does not have sufficient wages reported in at least 2 of those quarters to sustain a valid claim, they may not have a valid claim and may be getting determinations or decisions that say, I'm sorry, we see that you filed a claim and you were working for someone for the last 3 months, but when we look at your base period, you don't have sufficient wages. And I believe there was a question about that. As far as I know, needing to be monetarily eligible, needing to have sufficient money in the base quarter is not in the base period, is not something that has been waived. So if someone was not working during the base period, but was working for the last 3 months, they may not have a valid claim at this time.
Okay. Well, let's kind of look at that from a different angle in the reverse direction. So let me ask you this question, whoever would like to take this. Different opportunities for contract work right now, namely, say, grocery delivery services and folks who are doing some of these gig type economy jobs at the current moment. How does a gig worker, I guess I'll call them, how does their participating in that type of role, at least at this time on the side, how does that affect their eligibility for benefits?
Sure, I can answer that.
Okay,
so those individuals typically may not qualify for your standard Texas unemployment since they wouldn't have quote unquote wages in the relevant base periods to have a valid claim. However, the CARES Act is very important because the CARES Act section 2102 allows for unemployment benefits under temporary pandemic unemployment assistance, which applies to your gig workers, your independent contractors, your sole proprietors. So they can apply for unemployment through Texas Workforce. And of course, for the state unemployment side of it, they may get rejected due to insufficient wages. That's to be expected. But then we will flag those claims and process them to see if they qualify for unemployment assistance through temporary pandemic unemployment, PUA is what we're calling it. So they may qualify for that. In addition, there's that $600 through section 2104 of the CARES Act, I believe, and that applies to anyone who qualifies for unemployment, whether it be because they are fully unemployed, partially unemployed, or if they qualify for the temporary PUA. So they would file through TWC, follow the instructions there, and then we'll automatically flag those claims to see if they qualify for the pandemic unemployment assistance. And if so, then they could qualify for benefits in addition to the $600.
And if I may add to that, Brian, depending on your question there, if they're currently working right now, they could have a claim. So last week, maybe they didn't work any hours, like you're saying, it's a gig economy and there's just different kinds of jobs right now. Last week, maybe they didn't have any income coming in, and so they could get a benefit. This week, if they're working some hours, like Tommy was alluding to, that's fine. They would have to report their earnings to TWC as they're requesting benefits, and if they don't meet a certain threshold, TWC kicks in the difference. Tommy was talking about that, you know, how we want to encourage you to work more hours and bring more money home. So you can still be doing the gig jobs, basically doing that kind of employment, report those earnings. It doesn't invalidate your claim. It doesn't kick it out. Just report your earnings and TWC will get you to that threshold if you qualify for that.
Thank you. And Melissa, I believe it was you who was responding just prior to Elsa. You made a comment earlier, I believe, regarding unemployment tax rates. I want to revisit that just for a moment. We're getting several questions on that issue. So let me just ask whoever would like to take it, have there been any type of waivers for employers' unemployment tax rates increasing, given the obvious, rise in claims we're seeing?
Right, employers should not be charged for this. We have received word from the directors who instruct the investigators on these claims, and they have been specifically instructed, the investigators have, to not charge employers' accounts if the layoff or if the reduction in hours was due to COVID-19. So for that reason, I think it's very important when employers get a claim to respond to the claim, mention it was due to COVID-19, whether because you had to shut down due to an order or there's no more business coming in. So there's that connection there. But that's how employers should respond, I think, is to confirm it was due to COVID and protect the employer's account from charge. Tommy has a little bit more technical information to share on the back end as to how the tax rate may increase slightly due to some other issues with the ratios. Tommy, would you like to explain that?
Yes, that's due to the way that the State Unemployment Insurance Trust Fund is replenished for payouts, benefit payments that cannot be effectively charged back to individual employer accounts. Since there are so many unemployment claims due to COVID-19 that are resulting in chargeback protection for employers, that means that there will probably be an increase. Probably not too major given the size of the Texas economy, but still something that employers would notice in the state replenishment tax. And that's the minimum tax that applies to all employers, even if they've had no claims in the past 3 years. Every employer will pay the minimum tax rate, which is the replenishment tax. And employers that have had chargebacks over the past 3 years, they will have not only the replenishment tax, but also the replenishment ratio will be applied as a modifier to their benefit ratio, which is the 3-year chargeback total divided by the 3-year taxable wage total. That's the central component of the unemployment tax rate. And so there is foreseeably an increase in the replenishment tax and the replenishment ratio. In addition, there may be a deficit tax next year. We don't know that because we don't know what the rest of the year is going to turn out like, but that could happen. Historically, the deficit tax has been applied if there is a deficit in the Unemployment Insurance Trust Fund and Texas needs to borrow from the United States Department of Labor in order to fully pay all qualified claims. If that happens, the deficit tax may be imposed next year for experience-rated employers. And more on that will be available as the year goes on, especially during the month in which state unemployment tax rates are calculated for the next year, which is November of every year. By November, we should have a clear picture of what the 2021 tax rates will look like.
Thank you for that clarification, Tommy. We appreciate that. Kind of an interesting question that has come up through our Q&A feature here is asking about employees who might not have a Texas driver's license. They have an out-of-state driver's license, but they live in Texas. Can those folks apply for benefits in Texas?
Sure.
I'll go ahead and
take that, Tommy.
Oh yeah, federal law allows an employee who's out of work to apply for unemployment benefits in any state where they live or where they have worked or where their wages have been reported to. So it could be that there are some Texas claimants who might not have a Texas driver's license, but if they have a ID from other states, that'll be all that they'll need. And also, of course, their social security number. And if they have wages reported by other states, Texas will work with those other states to do a combined wage claim. So it really depends upon where they decide to file the claim.
Perfect, thank you. Now let's talk about the suspension of work search requirements. Since those requirements have been suspended right now, what happens when an employee might just refuse to return to work? How does that play out in terms of the benefits they're eligible to receive?
Sure, I can handle that. So, the idea, I think, behind what's going on right now is that everybody's on a temporary layoff. We don't have their set return to work date, but the employers are laying people off if they need to for the healthcare reasons or government mandates based on the healthcare reasons, with the idea that when the crisis is over, these people are going to come back. They're already trained. There are people. We don't want them searching for work anywhere else, right? So when the employer is ready to recall, and that's why we're waiving that. We don't want them to go find jobs anywhere else. When the employer is ready to recall the employees should be saying, yes, back to work. We are getting concerns from employers, however, that they're worried, and some have already basically experienced this, that some employees are saying, you know what, I want to stay laid off. I don't want to come back to work because I might be making more money on unemployment. So if that happens, or if employers are concerned about that, a tip from Belissa is make sure that when you recall your employees to work, make the job offer in a formal way. Have documentation that you have provided the job offer. Hey, Bob, hey, Susan, come on back to the same job that you had before, same schedule, same hours, same pay. Start on this date, can't wait to see you, okay? If they reject that offer of work, let us know, let the agency know, let TWC know, because when someone's getting benefits, that's fine and good while there's no work. But if there is work for them to return to, and in this case, it is suitable work for them, and that's important, the suitable work aspect of it. If they reject an offer of suitable work, that claimant, that person will then be disqualified from benefits. So they may not want to return to work, but if they refuse an offer of suitable work, they may find themselves with no job and then subsequently also with no more benefits at that point.
Ron, I want Tommy to add on to that. That was addressing an employer who may think they're making more basically from unemployment. But the other side of that is if they feel that the workplace is not a safe place to return to. Tommy, if you guys can address that.
Yes, that has come up as a question in a lot of these forums. For a lot of employer groups are getting this kind of question. And basically, if the worker works for an essential service and they are an essential worker for an essential business, and they've been advised of that status, and they aren't otherwise subject to any kind of stay-at-home or shelter-in-place orders by a local authority, and it's an OSHA compliant workplace, and the employer is making available to them proper protective gear and supplies such as gloves, a face mask, hand sanitizer, all of that kind of stuff. If there's no particularly valid reason for them to stay away and they refuse to come to an available job, they'll probably be disqualified. That's what our agency is telling various parties who ask and elected officials. This question has come up a lot. So if it's an otherwise safe workplace, safe working conditions, and so on, if it's just personal fear that is keeping the person away, that's probably going to be disqualifying. The employer should definitely raise that as an issue in any unemployment claim response that might happen.
And to add on a little bit of information to that real quick. So putting an offer in writing that they need to come back to work is very important. Realistically, when employers tell TWC about that, they'll question the claimant about it, and the claimant will often deny it. So you need proof of the written offer. Sometimes the employee will credibly say, I never got the text, I never got the email. So in that case, you may want to offer them in writing through several, maybe an email and a text message, maybe even a voicemail, try all three, because it goes to credibility. If an employee says, I never got the text, okay. But then if it turns into, I never got the text, I never got the email or the voicemail, it's questionable. So if you have that situation and you need to report that to TWC, call our fraud department at the following number, 1-800-252-3642. You can also email them at twc.fraud@twc.state.tx.us.
Thank you very much, Melissa. That's such an important point when it comes to the documentation and making sure that you have an actual record of that correspondence and your offer for them to return to work. So for all of our members, please make special note of that advice. When you are going to offer them their job back, please do so in writing and with a verifiable record of that communication. Okay, let me ask, because we, again, are getting several questions on the same subject, and this has to do with the CARES Act and how that plays into this again. So just for clarity for our members on the call today, when an employee qualifies for benefits or even partial benefits in Texas, does that extra $600 from the CARES Act, does it automatically go to that individual? And if so, when can that all be expected to arrive to that former employee?
Melissa?
Yes. So when can they expect it to arrive? I think payments are already starting up on that. So that's really good news. The $600 through the CARES Act is going to be automatic through the TWC system. We've been working with the system so that can be a go. So all they need to do is apply for benefits with TWC. And once they're approved, then we can flag those claims to get the $600 additional approved. Again, you're entitled to the full $600 if you're fully unemployed or even partially unemployed. If you go through the shared work program, through mass claims, temporary PUA under the CARES Act, bottom line is you get the full $600 through July 31st. All you need to do is go to TWC and file and get that ball rolling on that end.
And just to clarify, I believe the payments are going to start being made on April 12th. So they haven't exactly started yet. They are going to start getting paid on April 12th, and it's going to go back. It's going to be retroactive to week ending April 4th. So anybody who was asking for benefits at that time can go back to the week ending April 4th. They'll get paid out April 12th. And anyone who files a claim subsequent to that, it's not going to go backwards. It's going to go either back to that week ending or the date of their claim, whichever is later.
Thank you for that clarification, Elsa. And of course, it's hard to keep the dates straight because everything's moving so fast. But yes, today is the 13th. So hopefully,
True.
That means that employees will see that very soon.
Yeah, this is right. They should have. My apologies. The dates are changing, and sometimes I get caught in, that limbo. So yes.
Thank you. Let me ask a different type of question we've received a couple of inquiries from, and this is regarding the PPP loan proceeds through the SBA that our members, many of our members have been applying for the Payment Protection Program loan. If an employer rehires some of its employees due to receiving those PPP loan proceeds, does the employer need to notify the Workforce Commission?
So I guess I can take that. So if the employer receives the Paycheck Protection Program loan and starts basically recalls its employees to work or leaves them on leave, but it starts paying them their full wages, then either those employees are no longer going to be considered unemployed, right? They're going to be basically on paid leave, no longer unemployed. So those employees should stop asking for benefits, or if they request benefits, should report their earnings or the wages that they're getting in order to offset then the unemployment benefits. The employers can notify us. Like I said, the responsibility is on the employees to stop asking for benefits or to report those wages, but the employer can let us know just to make sure, because we're trying to avoid, again, fraudulent claims. So the employer can contact our office, or like Melissa said, if they do believe fraud is going on, contact the fraud line, but they can contact us just to check, for example, that the employees are complying with the requirements.
Right, and in fact, what we're hearing already from various lodging operators around the state is that the ones who are rehiring some of their staff, they are being rehired at reduced wages. So like you said, that would affect part of the benefits potentially.
That's correct. So they would want to report what they do make, and if they don't reach a certain threshold, then TWC would kick in some extra funds.
Now, speaking of rehiring and coming back to the workplace, let's transition for a moment and talk about what types of, say, medical documentation that an employer can ask for someone who has been away from the workplace for several weeks, whether they said they tested positive for COVID-19 or whether there was some other underlying condition or what have you. During this time we find ourselves, what can an employer ask an employee for medical documentation before coming back to work?
Sure, I can take that one. So can an employer ask for medical documentation that the employee is clear to return to work? Yes, they can in general. These are interesting times and there are a few twists to be aware of. First of all, if someone is not working and they're not earning money, it may be difficult for them to even afford to go to a doctor. So in that case, if the employer can swing it, they may very well recommend a physician for the employee to go to and pay all of the costs associated with that visit so that they can take care of that problem. The other issue is that it's hard to get in to see a doctor in many cases. They're not really taking patients, or they're only taking, the urgent patients. So it may actually be very difficult to get a doctor's note to clear you to come back to work. So there's no perfect answer here at this time. Yes, an employer can ask for a medical note. Here's what you don't ask for. Never ask for private medical information that you don't need to know, regardless of whether it's COVID or they have the flu or allergies, whatever it may be. You don't have the right to ask what their diagnosis is or what their prognosis is, generally speaking. But if you're asking for just a doctor's note to clear them.
And we lost you, Melissa. To clear them to return to work, that is fine. Under the Americans with Disabilities Act, again, the ADA, there should be no discrimination to employees based on their medical condition. So like Melissa was saying, it's none of our business as employers to know whether or not, they suffer from a certain condition. What the employer wants to know is that they're safe to return to work for either themselves, so they're not a danger to themselves, they don't get injured, and safe for everybody else in the workplace, since the employer has an obligation under OSHA to make sure that the workplace is safe for all of the employees.
Thank you very much. So we've had a couple other questions come through recently regarding eligibility, again, with different nuances. So let me ask you two questions. I think we can take these together. First question being, can sole proprietors file a claim? And then secondly, can an employee who is unable to work because they no longer have childcare file a claim?
Interesting. So the sole proprietor goes back to the original question, who's eligible? Under the pandemic unemployment assistance that came out from CARES, sole proprietors, independent contractors should be eligible and should be able to file a claim now and have benefits available. Of course, a sole proprietor is going to have to be able to show previous earnings, so they still have to show some kind of proof of how much money they were making as on their business. But yeah, sole proprietor can now file. So go to our website and red banner, 3 links, click on job seekers, and you'll find the resources for filing a claim and also an explanation of the PUA, the Pandemic Unemployment Assistance. Tommy, do you want to take the being available for work question?
Yes. In order to draw any kind of unemployment benefits, the claimant has to show and certify that they are available for full-time work, because even the people who aren't subject to work search requirements, they are subject to the requirement that if their employer once again makes a suitable offer of work to them, they need to be, going back to that job, unless there's some kind of urgent and compelling, very valid reason that they can't do it, such as medical, or there's, some kind of stay-at-home order. But even with the medical, they have to be medically able to work. And if they're, too medically incapacitated to go back to work, then they wouldn't satisfy that requirement of eligibility either.
Thank you for that clarification. We appreciate that. Let's see, what's our next area to cover here? Can someone speak to generally, I know that the commissioner, when we started the call, explained the Workforce Commission had recently expanded its hours 7 to 7 there initially with the surge of applications. But what can employees around the state expect in terms of, I guess I'll call it turnaround times with their applications? There have been a number of inquiries made to us about, hey, is there any way to check on the status of a claim that says it's, quote, in processing or under review? Is there any further guidance you can give our members about that?
Yes, I can perhaps contribute something on that. Just today, I got something from our shared work plan manager, Ms. Angela Ford, and she said that even though the statute says that the TWC has to respond within 30 days to a shared work plan request, in practice, they're getting those processed within 7 to 10 days after they're filed. It's just that progress reports are difficult to come by because they are so slammed with shared work plan applications that it's everything that they can do to properly investigate and process and approve them. So the approvals are coming within 7 to 10 days. It's just that they don't have the staffing to send out a lot of, progress reports. But those can still be obtained if an employer would really like to find out about that. They can email the shared work plan email address that's on the shared work plan page. I believe that's ui.sharedwork@twc.state.tx.us. And they can get a simple reply, yes, we have gotten your plan, we are processing it, we anticipate approval within 7 to 10 days, just basic information like that.
So Melissa, Elsa,
Thank you,
anything,
Tom.
is there anything, I was going to ask, is there anything on the employee side? I know we're addressing the employers, and so
Yeah.
we're there, but on the employee side, any numbers or along those lines?
Yes, so we're getting a lot also at our email, and you guys, employers, can email us with questions. We're getting a lot of employers who are trying to get information on behalf of their employees and saying, hey,
Right.
why are employees not getting benefits yet? I already responded. We all know it's because of COVID, because ultimately a lot of claims are coming in, but even if a lot and thousands were not coming in all at one time, there's still a process to go through just to, again, keep out fraudulent claims. So even, especially when people are throwing out, hey, the governor waived the waiting week, right? And I think everyone thinks the governor waived the waiting week, that means we should be getting benefits immediately. It still can take 2 to 3 weeks to start getting the benefits. So, if your claim's been approved and you've been asked to make payment requests and you've been able to do that, it doesn't mean you're not going to get your money. You just may not get it immediately. And that's the thing, they still need to get processed. So 14 days to 3 weeks. And mind you, I am seeing people getting paid and claims getting approved very quickly. When it's COVID related, I'm seeing on the other side of it, employers sending questions. It's like, hey, I haven't even responded, and I already got a determination that my employee's getting benefits, but you guys haven't waited for my response. So I think our UI department is really trying to speed these through and get them to the people who are entitled as quickly as possible, but do not despair. It does not mean immediately. 2 weeks to 3 weeks could be the time period.
And let me just jump in there for a moment and say that through all of our various correspondence with you all at the Workforce Commission, just so our members are aware, we would absolutely like to say thank you. Thank you for everything you've been doing in terms of, the commissioner mentioned, expanding hours, hiring a lot more staff to help process claims, expediting this as fast as we possibly can, as fast as you can. We understand that you are inundated with requests and doing everything you possibly can to do it in an efficient manner. And so on behalf of our industry, let us please say thank you before we, lose that context. Okay, I think we've got about 10 minutes left. I'd like to kind of ask the panel generally at this point, are there any other items that in your experience over the last few weeks, our members should be acutely aware of that maybe we haven't addressed yet on this call? So if there are anything that comes top of mind at that question, please go ahead and feel free to chime in at this point and offer that to our members.
Yes.
Brian, let me do it this way. Let me ask Kelly to join in on that, and then we'll circle around to Melissa, Elsa, and then Tommy. So Kelly, anything on your side?
Sure. Thank you, Commissioner Demerson. I just want to say that the PPP is clearly one of the most relevant supports or resources out there for all sectors, but especially this sector. There have been issues in the process, let's say, but I know that there's a constant effort to iron out those issues. And there is also a really significant effort to add more funds to the PPP to enable more and more companies to continue to avail of it. So I would urge everybody to keep a close eye on what's happening with that program. If you haven't applied already, please apply. More and more lenders are being approved, and like I said, there will be more funds coming into that program. Separately, but on a similar subject, I would say that our governor is going to make an announcement at 11:30, a specific small business announcement. So if you have time, tune in and listen to that announcement. Obviously, there are other resources. The EIDL loans are available. Cities and regions are offering local supports in the form of funding and other supports. So I would urge you, wherever you are in the state, to look at your city, look at your regional partnership, and see what else there is out there for you. But primarily, I think the big source of funds and support at the moment is the PPP program, and I know that there's constant effort to keep that moving and keep that pumping money into companies and keeping people employed. So that's my main comment. If there's any questions, please go ahead and ask.
Thank you, Kelly. Melissa?
Yes, so just a quick note on chargebacks. A lot of employers have been wondering, will we get fined? Will we get in trouble if we don't respond to a claim? No, you won't get fined or anything like that. And yes, chargeback protection should be automatic if people are filing due to COVID. However, mistakes happen. There's a lot of new investigators. Everybody is pressed for time. They're working as fast as they can, so things can happen. So with all of that in mind, I encourage employers to respond to the claims before the initial deadline. When you get a notice of claim, there's a deadline. Respond before that deadline to preserve your right to appeal. That way, if you do get a determination that says that you will be charged, you can appeal that decision and say, don't charge us, this was due to COVID-19, and we can work to protect your account. So I just wanted to throw that out there. You can't appeal those decisions unless you've preserved your right to appeal. So that's where that first deadline comes in. It's so important. Just give us a response before that deadline. And however you do respond, keep proof of it.
All right, Elsa? Thank you, Melissa.
Yeah, on other things is that on the employer emails and phone calls, we've had a lot of employers wanting to check up on their employees' claims. So they're hearing, I'm not getting my benefits, what can we do? And so there are resources, like Commissioner Demerson was saying earlier, for employees or job, basically the claimants. They can contact our counterpart, the Office of the Commissioner representing labor. That's Julian Alvarez's office, and I'll give you the phone number. Now this is being recorded, so I'll repeat it. It's two numbers. It's either 800-832-2829. That's 800-832-2829. Again, for the office representing labor, if claimants are having issues and would like to talk to someone, or 512-463-2829. That's 512-463-2829. And employers, contact us. And I believe our number, are you guys providing our number and our information to your
Yes.
Okay, so I won't go into that.
All right, and then thank you, Elsa. Tommy.
Tommy Simmons here. We have been receiving a lot of questions from employers recently about a related program that our agency has and enforces, the Texas Payday Law, which is Chapter 61 of the Texas Labor Code. And basically that's the law that says employees need to be paid in full and on time according to the wage agreement that was in effect when the work was performed. The question that is coming up most frequently is, due to closures and slowdowns and problems with mail delivery, employers are starting to notice that they have received wage claims and they are past the 14-day deadline that is on the employer notice of the wage claim for responding. I'd like to reassure everybody here on this phone call that the deadline for responding to a wage claim is nowhere near as important and set in stone as the deadline for responding to an unemployment claim that is also 14 days. Employers who are behind on responding to a wage claim should probably not worry. In the ones that I've looked up for companies calling about this, the wage claims have not even been assigned to an investigator yet. And that's because there's a lot more involved process on that. So employers who need to respond to a wage claim should go ahead and do so, even if they're after the 14-day deadline for the wage claim response, because you still have a chance to get your 2 cents worth in and influence the outcome of that wage claim. So by all means, go ahead and respond. And then if you want to check on the progress of it, you would be welcome to call the Employer Commissioner's office.
And Brian, this is Aaron. Thank you guys so much. Tommy and I are practicing our safe distance here, but we appreciate everything that you guys have done. Give Scott our best as well, Justin as well, and to the Texas employers on the line. We appreciate all that you guys are doing, making the investment in our state, hiring our Texas employees. And so thank you so much. After this, we're still available. And so as the questions comes, if anybody's green lighted to do anything as it goes further and you have questions, we want to be there for our employers. But thank you guys for doing this. We appreciate your memberships very much, your members very much. And Elsa, Melissa, Kelly, and Tommy, thank you guys so much. Brian, we'll turn it back over to you.
Thank you so very much, Commissioner Demerson. It's been a pleasure to host this call with all of you this morning. I know that our members have gotten a lot of value from it. And let me just remind everyone on the call that this has been recorded, the entire session. We also have other questions, I believe, that have come through the Q&A portal. We will make sure to go through those questions and make sure that if there is anything that got unaddressed during the last hour, we will make sure to get those answers and to provide them to you as early as possible. I believe it's about 4 minutes prior to the governor's scheduled announcement at 11:30 this morning regarding small business, as Kelly alluded to. So we want to make sure that we can end the call in time for that. And again, for our members, just an FYI, we will of course apprise you all of whatever announcement comes from the governor today regarding the effect on small business. So on behalf of the Texas Hotel and Lodging Association, our CEO, Scott Giles-Love, our full legal team, again, thank you to the Texas Workforce Commission. Thank you to the governor's office. And please look for further correspondence from us. And we appreciate your being on the call. Everyone have a good day.
Thank you.
Thank you.
You too. Thank you.
Thank you.